SJC-12915, Commonwealth v. Jorden Terrell, and SJC-12916, Commonwealth v. Gabriel Lopez.
I believe Ms. Briggs is first.
Yes, Your Honor. Good morning. Katherine Briggs on behalf of the Department of Youth Services. May it please the court. The two issues before the court today are whether the Juvenile Court has the authority to order the Department of Youth Services to grant credit to a youth for time spent in detention, and whether the fact that credit is not given violates a youth's right to substantive due process and equal protection. The existing statutory scheme in Massachusetts does not give the Juvenile Court the authority to grant credit, to order DYS to grant credit to a youth. The statutes are silent to the issue for two reasons. First, under general laws, Chapter 119, Section 58, youth are given indeterminate commitments to a certain age by the Juvenile Court. They are not sentenced to fixed periods of time. Second, once committed by the court, the Department of Youth Services is mandated by Chapter 18A, Section 2, and Chapter 120, Sections 4 through 6, to assess youth, provide treatment, rehabilitation, and supervision. Within this framework, the idea that one should earn credit towards treatment that DYS is statutorily obligated to provide makes little sense. Efforts to read ambiguity into the scheme by arguing that there is tension between a judge's mandate under Sections 53 and 58 and DYS's mandate under Chapter 120, Sections 4 through 6 and Chapter 18A, Section 2 fail. The statutory scheme clearly divides authority between the court and the Department of Youth Services. The court is authorized to commit a youth, and DYS is vested with the authority to treat the youth. The Juvenile Court's order to DYS to grant credit for time spent detained against assessed treatment time infringed on DYS's statutory authority because it would force DYS to disregard a youth's treatment teams in favor of crediting time. The department is bound by statute to administer the appropriate treatment as determined through a comprehensive assessment of a youth's particular needs. To grant the credit, as ordered by the court, would force DYS to violate this mandate. The second issue before the court is whether the long-standing practice of not giving credit to juveniles for time spent in detention violates a youth's substantive due process and equal protection rights. This practice does not violate those rights. Although the denial of credit may implicate an individual's liberty in the broadest sense of the term, credit for time spent detained is not a fundamental right. The concept of jail credit is the product of statutory construction and not required by the Constitution. Age is not a suspect classification either. Therefore, the rational basis test is appropriate for analyzing this practice of not giving credit to youth who spend time in detention prior to their adjudication by the Juvenile Court.
Ms. Briggs, I'm just going to stop if I could for a moment and go back to the first issue and the issue of remand that the juveniles have brought up. Their view is that we have an intractable factual dispute here. For instance, in the Juvenile Terrell's brief, he says that confinement is harmful to youth by almost every metric of well-being, including psychological well-being, long-term vocational and educational prospects. Your position is that with an indeterminate period of time, that DYS, in order to be able to provide treatment, has to be able to have the option of how long this treatment in a secure facility should be so that you can provide that type of intensive treatment for rehabilitative and public safety purposes. They both can't be true. Does that issue need to be resolved for us to be able to address this case?
No, I don't think you need to address the tension that exists between some of the existing social science research and the practice of the Department of Youth Services to use hardware secure treatment time as part of its continuum of services. there may exist some tension in the social science research, but I think what the social science research also says is that some period of time can be helpful. And it is when it is sort of, if you look at, and the social science research points to a sort of a period of time where confinement in that sort of setting, confinement for treatment purposes, might not be helpful anymore. So I don't think resolving sort of that tension that exists in the social science research is necessary to move forward on this case. I think the statutory scheme in Massachusetts is clear with respect to DYS's authority under the statutes with respect to treatment. And I think that in terms of the law, I think the law has recognized that we have this broad scheme. And I don't think that the juveniles in this case have shown that that there is really a need to address that more in depth to sort of get to the heart of this issue, which again is what the statutory scheme sort of allows for between the Juvenile Court and the Department of Youth Services.
And what about the grid? We have DYS's position that the grid is helpful in order to determine how much time is appropriate in a secure facility, and we have the juveniles' position that no, without exception, at least in the Bartley-Fox context, but perhaps beyond that, the grid is dispositive, and at best you can move in one direction, one way up or one way down. And do we need to know the answer to that in order to be able to resolve the issues that we have in front of us?
I think you have the answer to that. The grid is one part of sort of the classification process that's outlined in the regulation. There has been no evidence presented to the contrary. I don't think that that there is evidence that shows that we use it in a more sort of strict sense. And the grid also, as evidenced by some of the later documentation that came in, and specifically with the motion to remand, that particular situation that's addressed there shows that the grid isn't always applicable to every single youth that comes before it comes into the classification process with the Department of Youth Services. So again, I think you have enough to sort of to make the determination that the grid is used how we say it's used. My other point with respect to the grid is if you look at what's allowed under the regulations as to how the grid is used. The grid, the department is allowed to deviate generally one level down or one level up from the recommended grid time. Now, with respect to 10A charges, that can be a range then of 5 months to 24 months of time spent in a residential treatment setting. So that alone is evidence that it is not used in the sense that the youth are imploring this court to look at it, that there isn't this sort of, it's not a mandate, it's not a definite period of confinement, it's really a range, it's a recommendation, and the court has the evidence to rest, to show that the department does in fact use it that way. Just to continue as the constitutional argument that's also presented here, Massachusetts law recognizes delinquency as both legally and constitutionally different than the adult criminal system. The appellees argue that a commitment to DYS is the same as an adult criminal sentence, but this belies this previously established legal difference between the two. The Commonwealth has an undeniable interest in both public safety and the treatment and rehabilitation of youth. And as explained at length in the briefs, pursuant to its statutory authority, the Department of Youth Services assesses and treats youth along a broad continuum of services so that they may safely return home and to the community.
Ms. Briggs, can I ask you kind of a fundamental question, and forgive me if it's too basic. If someone is sentenced or adjudicated to DYS till they're age 21, how often is it that they actually, how determinant is it that they would stay? My thought going into this was people don't stay till they're 21, that all sorts of different things happen. So a DYS commitment doesn't necessarily mean for any term. But counsel say otherwise. What's your position on this, and how often do people get released?
So that's your sort of assumptions are true. That a commitment to 21, a youth would not spend, let's say for assumption purposes that they are committed to 21, closer to the age of like say 17 or 18. They do not spend that entire period of time in a residential setting. The goal of DYS sort of treatment is to get them to a place where they can be released safely back home and to the community. DYS, again, does have that broad statutory authority if something happens once they are released in the community on what we call a grant of conditional liberty. We then can bring them back into a residential setting for a period of time to, again, try to continue that treatment to get them into a place, again, where we feel it is safe to send them back home and into the community. So it is this fluid sort of process, and that's why it's important to look at a commitment as a whole and not just sort of this one part where a youth may or may not spend time in a secure setting, because not all youth will spend time in a secure setting, and not all youth will spend time in a hardware secure setting. We do have staff secure settings, and our continuum goes from sort of from hardware secure all the way to group homes and foster care. Is there another question? Yes.
No, just Katherine.
I'm trying to understand the briefs on youthful offenders on gun offenses. Isn't there a set time for at least one particular class of juvenile offenders, these youthful offenders with gun offenses, or am I misreading the briefs?
So there is the only set time for youth who are charged with certain gun offenses are for those who are adjudicated delinquent. Written into Chapter 119, Section 58 is that limitation. It's paragraph 7 and 8.
That's in those, even though delinquents are generally considered less serious offenses than youthful offenders, the delinquents can get a set amount of time, right?
That's correct. And if you look when the youthful offender sort of scheme came into play, it expanded sort of the juvenile court's ability, sort of options with respect to youth who are then indicted youthful offender and adjudicated that way. That is why they are not addressed, I would sort of argue, within the Section 58, because there's this additional sort of scheme with respect to only youthful offenders.
We shouldn't give credit even for this limited class that have a set determined sentence, or it's not the word sentence is improper, but the set determined amount of time in confinement?
No, I think that when you look at, again, the purpose of a commitment, and it's impossible sort of to be able to credit just treatment time. And that is really what especially the court in this situation was trying to do, is take the time that a youth may have spent detained pre-adjudication and apply it only to treatment time. And a commitment is to a certain—
They're not asking for that, right? The relief they're seeking is not limiting the amount of time of treatment. They're conceding that you can keep giving treatment up until 21. They're saying that the confinement time can be limited, but not the treatment time. And you should be given credit for the confinement time. It's a narrower argument. And also in response to Justice Lowy's point, it seems like even if we accept the facts from your perspective, there's going to be a determined amount of time for everybody in confinement, just one level below the grid number. So isn't everybody subject to a predetermined amount of time here?
No, sorry, go ahead.
Go ahead. But that's, my question really is, they're really only talking about confinement, not treatment. And it appears that we can determine for almost everybody here how long their minimum amount of confinement is going to be.
It's impossible for a court to know what the assessment and treatment process will sort of determine the specific risks and needs of a youth are. Again,
treatment from confinement, because that's what they're doing. Your opponents are separating treatment from confinement.
but
I
you
don't know if
can't,
they can- Go ahead.
sorry, I apologize.
No, go ahead. I'm cutting you off. Mhm.
You can't separate treatment from confinement because treatment, it's the entire, it makes up the entire commitment, and within sort of, again, a commitment, there are, the role, residential treatment plays a specific role for youth who are determined to need that based on the risks that they, and sort of the assessment, the assessment determines about their specific needs and risks with respect to treatment. So it is not a set period of time. Even once a youth is given, again, a range of potential time in a residential setting, that is, they participate in sort of monthly treatment meetings, in a regular schedule of sort of reassessment based on their ability to sort of comply with the treatment and make progress within that particular setting.
If you're done, Justice Kafker, Justice Cypher has a question.
Yeah, I do. And my question is, counsel, what is the range? So a judge is concluded the trial and is making a disposition. What is available to the judge at that point in terms of making that disposition?
A judge doesn't have the authority to make that determination.
Right.
So that's why it's important to look at this
Right.
specific
So my next question is, if that's the case, what's the point of giving anybody time served or time credited? Because you've got complete discretion with the grid. It doesn't seem that it would make much difference in the end. You use your discretion, and if it's appropriate, you can give it to them, and if it's not appropriate, you can't. What binds you to that kind of recommendation?
We're not bound to a recommendation for credit. You're right. Given we do, again, the statutes are very clear with respect to DYS's mandate to perform an assessment and to determine the appropriate treatment that's needed based on the specific risks and needs of a youth. So we, if hypothetically an assessment determines that a youth needs 6 months of treatment, but a court prior to that process even starting asks that, or orders DYS to grant 3 months of credit, that the fact that 6 months of treatment was still assessed and found to be needed for that particular youth remains. And if the department were to then subtract that time, it would interfere with our mandate.
Okay.
Just Lowy.
We lose you, Ms. Briggs. The juveniles make a very straightforward argument that the BMC and the district court can provide time held pretrial, as can the Superior Court. And we have Chapter 218, Section 59, that gives the same authority to the juvenile court as other courts. And their straightforward argument is, therefore, a juvenile court judge has authority to provide pretrial detention time as credit.
The juvenile court is a court of specific jurisdiction, and whereas here there's a complete absence of any discussion of credit, time served, even the words sort of incarceration, sentencing, prisoner, they're not used in those statutes, and it's because they don't apply. So I think their straightforward argument is not as straightforward when you look at sort of why the juvenile court exists, and again, the statutory sort of a scheme that exists for both the court and then for DYS.
Just Bud. You're on mute.
Thank you. Does the DYS ever take into account the amount of time that that a juvenile has spent in confinement pre-adjudication? I mean, I understand the DYS has the responsibility for treatment, and that's very important. I think one of the arguments being made is that there's not a whole lot of differentiation the type of individualized treatment options aren't necessarily being made. And so I guess my question is the period of time spent in detention pre-adjudication taken into account ever? How long is the average juvenile, for this particular crime, how long are they in detention pre-adjudication? And so are those things taken into account?
So yes, the DYS does take into account time a youth may have spent in detention pre-adjudication. It's not done with the mathematical precision that say it's done for an adult, but it is taken into consideration by our regulatory sort of stand. If you look at our classification regulation, it is part of what goes into that determination. As to sort of DYS, and I think it's important to understand that DYS takes very seriously youth who's sort of the idea of youth spending time pre-adjudication in detention. We are sort of, as explained in the brief, the home of JDAI, which is a national sort of organization that looks specifically at how how and why and how long youth spend detained pre-trial. So it is a consideration. Again, as explained in the briefs, that we look at those numbers. Those numbers are published annually. And it's part of our mandate, again, under Chapter 18A, Section 2, to look at sort of to look at our numbers and to perform sort of research and to keep up to date on sort of what's happening within our system, how we can better our system based on existing social science research. So it is taken into consideration, just not with the mathematical precision that it is in the adult system.
Thank you.
Any further questions? Thank you, Ms. Briggs. Ms.
Thank
Steele? There you go.
There we go. Good morning. May it please the court. Melissa Allen Celli for the juvenile, Gabriel Lopez, docket number 12916. In this case, Attorney Jellison and I will be splitting our time in the oral argument. I will be discussing the constitutional issues, and Attorney Jellison will be discussing the juvenile court's authority beyond the Constitution. We're placing the constitutional issues first here because the constitutional arguments underscore the deeper issue in this case, and that is the issue of fairness. It is very easy to get bogged down in the factual disputes between the parties in this case. But as the Supreme Court recognized over 50 years ago in re Galt, it does not matter what we call these places of detention or how benevolently motivated they are. We are confining children in a building with regimented routines and institutional hours, in a building with guards, custodians, state employees, and other delinquent children, rather than parents, siblings, friends, teachers, classmates, and other mentors. This is a liberty deprivation, and the Constitution zealously protects children against it. It is not fair. At the outset, the juveniles would like to clarify what they are and are not asking for. We are not asking that the juvenile courts take control of juvenile treatment. We are not asking that juvenile courts determine the length of time that a child spends in DYS treatment. We are not asking for juvenile courts to determine what type of treatment children receive. Those decisions fall squarely under DYS's statutory mandate, and no party here disputes that. What the juveniles are asking is that children be treated fairly. We are asking that the government, DYS, narrowly tailor its efforts to advance its compelling state interest by upholding the juvenile's substantive due process rights and equal protection rights. And we are asking that the government, DYS, implement their actions fairly in order to uphold the juvenile's procedural due process rights. We are asking this court to uphold the juvenile court's order in these cases and allow these juveniles to receive credit for their time served in pretrial detention. We are asking that this court credit the juvenile court's determination that, at least with respect to so-called Bartley-Fox crimes, the time that the child spends in post-adjudication confinement, even as a youthful offender, is de facto mandatory, or is at least not fully grounded in an individualized assessment of a child's treatment needs. And we are asking this court to recognize that before DYS can refuse to grant credits for time served in pretrial detention, it must make an individualized determination, not confined by Bartley-Fox laws and not confined by the grid, that that child's individual risks and needs require that additional liberty deprivation.
I could interrupt you for a moment. And first of all, DYS position is that there's no fundamental right to these pretrial credit. But let's just assume that there is a fundamental right because there's a deprivation of liberty involved. And I also believe they mentioned that age is not a suspect class, but let's take into account our concern for juveniles here. Their position is, whether it's rational basis or strict scrutiny, that this all dovetails back into the first argument, that they do have a compelling state interest in rehabilitation, and that includes the ability to have the option of a secure facility for that rehabilitation, and that they have a compelling state interest in public safety. Now, I know you disagree with that, and on one of the briefs, I won't go through the whole list. There's a whole list of reasons refuting that. I'll just mention one of them, which is that you're isolated from your social peers and education to some extent. But doesn't this all go right back to the first issue, which is, whose facts are we grabbing onto to resolve this?
Your Honor, I would actually agree with much of what you said, which is to say that I agree that DYS has a compelling state interest. I would also agree that that juveniles do not have a fundamental interest in, quote, jail credits. However, just like in Brangen, where individuals do not have a constitutional right to bail, to the extent that bail, or in this case, jail credits, implicates a liberty interest, there is a fundamental right to the liberty interest. So I would say that this does fall within strict scrutiny, just as Brangen did. And here, while I think that you're right, that factual determinations would be helpful in deciding how narrowly tailored DYS's actions are in reality versus what their statutory scheme and their regulations say. However, what I can say is that a blanket refusal to provide jail credits, that does not have any of the hallmarks of narrow tailoring. It does not have any of the hallmarks of an individualized determination. And so even if this court were not to hold that substantive due process precluded the prohibition on jail credits, at least juveniles are entitled to procedural due process protections before they can be subjected to this increased liberty deprivation. That would include notice, an opportunity to be heard, written findings describing why specifically in this case jail credits are not appropriate. None of that is happening now. So while I agree that factual findings would help this determination significantly, in particular to address questions like the question that Justice Budd asked, which is how frequently are jail credits provided? You know, those sorts of things. It's one thing to say we consider these things. It's another thing to say that in reality, on the ground, that they're actually reducing sentences on account of the time spent in pretrial detention. And we simply don't have that information right now. I'm sorry, Justice Gaziano.
No, I just wanted to clarify something with you, please. You agree with the government that, or with DYS, that the jail credits are a creature of statute, and there's no due process right in and of itself to jail credits.
I do agree with that.
Okay, so and then you want us to look at Brandon to say what's fundamentally fair, but doesn't fundamental fairness have to do with due process? That's why I'm a little confused.
Yes, it does have to do with due process. So I think that due process is the linchpin of this entire argument. We have both substantive due process and procedural due process at play here. And as one of the concurring opinions to Galt said, in a case like this where the substance and the procedure are so intertwined, it's challenging to determine which is at play.
What about the procedural due process inherent in the DYS sentencing scheme, which heavily involves counselors, heavily involves defense counsel? I mean, more so certainly than the adult sentencing scheme.
So at the moment, children receive no notice on the point specific to jail credits because they're just not provided. So children don't receive notice or an opportunity to be heard on the issue of jail credits because it has never been an issue that is legitimately on the table for them. So what we're asking for is, at the very least, from a procedural due process standpoint, that the possibility of a one-for-one jail credit be on the table such that it is something that juveniles could argue about.
And I'm going to ask, and I'll ask Ms. Jellison because she's going to argue the nuts and bolts of it. From your perspective, as far as procedural due process goes, would that be accommodated by the ability for counsel to argue to DYS, referencing their own regulations for increased jail credits?
I think that's a possibility. However, under the current scheme, DYS still limits the amount of deviation that can occur. And so in my client's case, for instance,
I'm sorry to cut you off, but that's because it's a Bartley-Fox and because of the grid.
It's because of the grid, exactly. And so, for instance, in my client's case, even if you ignored Bartley-Fox, he would be subject to a grid level 4. That receives at the maximum end 12 months in confinement. If you went from that maximum grid 4 to the minimum of grid 3, which is 5 months, that's a 7-month differential. So the most time he could possibly receive off is 7 months under their current scheme. However, my client spent over 8 months in pretrial detention. He simply cannot receive one-for-one credit on the basis of the scheme that they've outlined.
Thank you. Now I better understand your argument.
Thank you. I see that I'm over time.
Does anybody else have any questions for Ms. Shelley? Thank you, counsel. And now we'll hear from Ms. Jellison.
Good morning, Associate Justices. Eva Jellison for Mr. Terrell, and I wish Chief Justice Gantz a speedy recovery. I am going to be addressing the non-constitutional bases upon which the court could affirm the juvenile court's order of jail credits. And I'd like to start with one of the justices' questions. It was Justice Gaziano's question: is jail credit a creature of statute? And jail credit is a creature of statute, but it's actually a creature of both statute and an abiding sense of fundamental fairness. In the adult sense, I made an argument in my brief that you could rest this decision on a non-constitutionally based fundamental fairness. And this court has done that several times when it comes to credit for time served for adults. There are a number of cases. Commonwealth versus Maldonado is one in the appeals court that collects a lot of these cases, but they all involve situations that were not covered by the jail credit statutes, but did involve time served on a certain crime that was then applied to the sentence on that crime. And what it said in a lot of these cases was, we're not going to say that this is a constitutional issue, but if we didn't give this person credit for the time that they served, it would become a constitutional issue. So I don't know precisely why the court rested it in this non-constitutional fundamental unfairness. I saw that also with some of the civil commitment cases where the court had rested its least restrictive analysis on a fundamental fairness type notion rather than grounding it in the Constitution. And in matter of a minor, this court then grounded that least restrictive alternative in the Constitution.
Okay.
And sorry, Justice Gaziano.
Yeah, can I ask you the nuts and bolts question? I take your argument well. and I think it's your brief that lays it out nicely, but under your view, when we get to the regional review team, the RRT, is that when this would take effect? How does this work in the real world?
Yes, the judge would order a precise amount of credit based upon the time that the juvenile spent in pretrial detention, no more, no less. We wouldn't know what that really meant until we got to the RRT. The RRT goes through a process that's substantially confined by the grid based on DYS's own assertions and the assertions of every juvenile defender that I spoke to and put comments from in affidavits. At that time, DYS assesses an amount of confinement time. DYS can treat a child the entire time they're committed. They set the conditions on grants of conditional liberty, which include different types of treatment. So DYS has the ability to help children the entire time. But the confinement time, the initial confinement time, is set at the RRT. And all I'm actually asking for is a presumption of earlier release based on jail credit, because I acknowledge that DYS actually has substantial authority to confine a child for more time. If they get to one of the reviews, I don't know if they do it at the 90, 60, or 30-day review, but perhaps they get to the 30-day review, the child has not made progress. DYS then goes through a process protected by certain procedural, there are certain procedural protections in that process, and they could extend the child's commitment. But I would imagine, and what it seems, I think fact-finding would be helpful in this case, but it seems as if a child does well, goes to school, participates in treatment time, they would get out at that earlier point, the initial confinement assessment minus the jail credit.
I believe Justice Lowy has a question, then followed by Justice Kafker.
Justice Lowy?
Sure. I agree that you really are not asking for much because of the reasons that you gave, and that you're not saying that there should be a limitation on how long the period of DYS commitment is. You're talking about secure facility time. And I also think Justice Kafker's point is well taken, that the Bartley Fox, the delinquents, are sort of, because of the Connors case, in a little bit of a different circumstance. But nonetheless, DYS's position is, in a way, exactly that since they have this flexibility in the manner of treatment, and that they can reevaluate treatment, and even if they have said, okay, this amount of time is in a secure facility in this case, they can lengthen it, that it all feeds in to the point that this is an indeterminate period of time, and that pretrial detention credit just doesn't fit in the statutory scheme. I think that's a response to what you just said.
So I think that you could fit it in with the way that DYS seems to operate, and I do agree that fact-finding would be helpful on this basis. If indeed DYS very rarely deviates down, especially on gun crimes, the amicus brief makes that a little bit clearer in their affidavits, that especially on gun crimes, they don't see much deviation from the 8 to 12 months. And the 8 to 12 months is offense specific. This is not based upon a child's individual needs. It can't be based on the risk assessment. It's based on the grid level, and that's offense specific. So I think you really could take this off for most children. Although I'll have to say, the juvenile court judge's order does not specify how credit is to be given. And to the extent that DYS did give some form of credit, or this court could tailor the credit, determination to better fit the juvenile system, that would seem to be acceptable. What we're stuck with right now is no credit plus this grid system that they seem to strictly follow. So I'm a little bit at a loss because of the factual disputes, but I believe you could implement it, or implement it in another way. And just to the point, we all talked a little bit about, does DYS give credit for pretrial detention through these individualized assessments? And it seems that DYS is saying, yes, we do, but we do it when the child has been good in DYS pretrial detention. And you're taking a child out of their community, strip searching them, putting them in institutional clothing, restricting their liberty. They can't see their parents whenever they want to. They can't move around whenever they want to. This isn't the comforts of their home. This is a significant deprivation. And if the child doesn't react well to that deprivation, DYS isn't providing them with credit afterwards. They're only really assessing the child better, to have a lower confinement assessment, in my understanding, if the child performed well. And I think that that just doesn't take into consideration the severe deprivation and the severe unfairness on children who can't necessarily perform well in pretrial detention. I
think Justice Kafker had a
Oh,
question
absolutely,
before you move on.
I'm trying to work within your structure, which is that treatment will not be, you concede that they can treat the juvenile until 21, right?
Yes.
All you're seeking to do is limit the time of confinement, but confinement is deemed necessary for the treatment in many ways, right? You're getting
sorry.
Let me set it up and then you can answer. But meaning you're taking the child out of the environment that's deemed to have caused a lot of these problems, at least temporarily. Without a factual record, how do we separate treatment from confinement as neatly as you're trying to do here?
I would suggest that a factual record would be incredibly helpful here. That was the reason to file such a strange motion pre-argument. After reading DYS's reply brief, that seemed to be the most appropriate way to resolve some of the issues in this case. So I would agree with Your Honor. I would like to point the court to General Law, Chapter 120, Section 6, which is the statute, the enabling statute for DYS that defines how they can, the ways that they can confine children and what they can do with children. And I would note that Section B says that you can order his confinement under such conditions as it believes best designed for the protection of the public. So even DYS's enabling statute does not say that confinement is a part of treatment. It suggests that it's for the protection of the public, and that's very consistent with the grid. That matches the adult classification system. When we see a certain crime, we think that people need to be removed from the community for a certain amount of time. So even DYS's enabling statutes and the grid kind of suggest that this assertion that they have that confinement is treatment time doesn't quite square with the mandates of even DYS. So I do think we could use some fact finding, but I believe that that also would help the court in resolving these issues to look at that.
Any further questions from Ms. Jellison? Thank you, counsel.
Thank you very much.